Economic International Affairs Scrutiny Panel.
Deputy Karen Wilson, Vice Chair.
I am Deputy Max Andrews, a panel member.
I'm Ian Gorst, the Minister, and I'm joined today by
Helen Delacour, Director of Financial and Professional Services.
Tom Lefevre, Director of External Relations.
And Julie Keir, Associate Director of Financial Services.
Thank you. Welcome again, and thank you for coming in. I'm going to start off the proceedings, if that's okay. So the first question is really relating. The first questions relate to the legislative programme. So, in other words, what is coming down the pipeline from your department and work streams, Minister? So, have there been any changes to your legislative programme for 2025, and can you tell us about them, if so?
So, as you know, in the run-up to the budget, one of the pieces of work that was done was to look at all of the legislative projects in the pipeline. I understand there was initially a total of 129 projects, and we know from experience that there's roughly about 50 that get through in any or manage to make it in any calendar year. So the revised list includes about 59. We, of course, needed to just think about, okay, what do we want to get over the line between now and, in effect, really the election? What are the critical ones? So we did that. I'm not aware of any bits of legislation that we had to say we weren't going to do. They were always going to be take longer than we might have thought. So on the prioritised list for FS, we've got consumer lending. I might want to talk about that later. We've got the legislation which will create the independent FIU. We've got some changes to companies law. That's at consultation now on the principle of those changes, and we've got limited partnership changes. When it comes to ER, generally speaking, of course, our ER legislation is much narrower in scope. It's more around sanctions, changes, and those sorts of things. There's a couple of civil aviation issues which are almost complete, so they will continue on. When it comes to sanctions, there's mirroring what's in the UK director's disqualification sanctions, and we'd expect other minor things to carry on during the course of the year. Of course, quite a number of sanctions things are undertaken by order and special licence, so law drafting have to do all of those as well. Areas which are connected with external relations but not directly within its purview as well will be ensuring international compliance. So we know that Tom is just fresh from South America signing us up to the CARF, which is the Crypto Asset Reporting Framework, which comes out of OECD, so that will need to be legislated for, and there are changes to the Common Reporting Standard as well coming from the OECD, and they will need to be legislated for.
Thank you. When you talk about sanctions, is that just a list given to Jersey? How does it work for what kind of sanctions generally apply?
If there's people added to the UK sanctions list, or UN sanctions are introduced, or we need to mirror changes around sanctions elsewhere.
Okay, thank you. So in terms of the reprioritisations, could you tell us, I think you've touched on it already, but how are the reprioritisations assessed, and also what consideration is given to the impact about how the reprioritisation is made?
Well, really, from my perspective, there were two elements. One is looking at what's critical for Jersey from an international compliance perspective, and what really remains a competitive from a competitive perspective, and then I suppose over all of that you lay the political priorities as well. What I should say is there is also the ECU changes legislation, which we've continued to work with Law Officers Department on, and they will themselves, I think we've agreed that they will provide some extra resource to make sure that that gets over the line as well in that prioritisation.
Could you just say for the record, sorry, what's ECU?
The Economic Crime and Confiscation Unit that currently sits within the Law Officers Department.
Yeah, thank you. Okay, and out of those 59 areas that you've identified, what's the realistic likelihood that you'll get through all of those?
So 59 are across government.
Right.
The ones that we've got in our department are just the ones that I outlined to you there.
Do you have a number for those?
1, 2, 3, 4. That would be about roughly 5 big pieces, are there?
I was
Yeah.
going to say.
There's a number of other items that weren't actually included in that prioritisation list because they were so far advanced anyway that they were going to be over the line either towards the end of this year or early next year. So we knew that those would be finalised in the current government.
And are there things you'll have?
Remind us of
Sure.
of
So
what they are.
the trust law, we've had a consultation on amendments to the trust law earlier this year. So that one's almost done. And also there's some work ongoing that you would have seen, I think, and picked up in the media around credit reference agencies' access to data. Again, that's just a minor order that we need to make once we've got the operationalised piece in place.
Thank you. Thank you. And the last question from me on this section, and I'll see if my colleagues have got any follow-ups. Have you got any, can you confirm when you expect the consultation on the crypto asset reporting framework to be held? Is that something that's on the?
Yeah, it's out for consultation now.
Okay.
Can you just check, Julie, when it's?
I think it's comments invited by February.
13th of February.
Yeah, 13th of February. There's a note on it, Minister, in your pack. But comments by the 13th of February. Then there will be a further consultation on the draft legislation that will be in the first half of the year. And the intention will be then for the law to be presented to the Assembly in the autumn.
Yeah.
Just by way of background on it, this is an OECD initiative and it is an international standard. So it's one of those things that jurisdictions are expected to implement.
Yeah.
The new rules will come to force from the 1st of January 2026. Can
you tell us what's meant by a reporting framework?
Yeah, so basically what this is about is saying that, well, Minister, if you're happy for me to do that, crypto, digital currencies, they represent potentially, some new and unusual threats in the sense that they are obviously decentralised. They have the possibility for there to be a disconnect between the owner of the asset and the asset itself, and therefore the OECD, I think, rightly takes the view that they have some of the characteristics that could be problematic. And so the intention behind this new standard is to provide a framework so that jurisdictions can exchange information about the ownership of crypto asset funds, and that then will help ensure that there is greater transparency around them. So the way to think about it, I suppose, is an additional form of exchange of information and transparency in what is a new and valuable area of activity.
And is it to do with beneficial ownership as well? Does it have any of those considerations?
It will be in terms of who are the owners of those assets. Yeah. So it's trying to ensure that jurisdictions can exchange information so that they have a greater level of transparency around the ownership of those. It is worth saying, based on the discussions we've had, this is not a major area for Jersey in terms of Jersey isn't a large centre for this. But we take the view that we are committed to OECD standards. That's a hallmark of the jurisdiction. And just like Guernsey and the Isle of Man, for example, we were in the forefront of those jurisdictions that said that we would sign up.
Yeah.
Minister, can I ask, do you think there will be a need for external consultants for this particular work stream?
I wouldn't envisage it, no.
No.
It's an OECD-led proposal. It's a framework. As Tom just said, that we, at this moment in time, it's not an area that we have very many structures or service providers that would come within this framework.
No.
But we've always taken quite a robust approach to dealing with crypto assets and how we try to regulate them. So we thought actually it was quite important that we were signed up to the framework, that we put the framework into domestic legislation, so that that message, even though it's becoming more and more of an issue and more fashionable, this is what we see happening across the water, it's important for us that we continue on that. There are risks that we need to mitigate, and we need to be clear on that from the start.
Sorry, Minister, just given the interest in cryptocurrency generally worldwide, if we're not prepared for the interest, how are you going to manage the risk around that?
No, I think we are prepared for the interest.
But in terms of
question,
scale?
the question is, what do we do with the interest, and how do we clearly say that we will be robust when it comes to regulation? And one of the ways that we do that is through this new CARF framework. So it's not that we're not open for business. We are. Like all things, we're setting out our stall very clearly that if you come to Jersey in this sphere, we will only accept your business if you can meet these fairly robust regulatory requirements.
And so just to be clear, so we're ready to apply those standards now?
Well, we will be. We've signed up.
Yeah. So the timescale for compliance around those?
Well, as we say, it's going to be in place by, we just have that date there, 1st of January 2026.
Okay.
But by signing up, as Tom did last week, it sends that message that, okay, you're not going to come to Jersey for the sake of it not being in place for a year, because we're quite clear on where we're going to and where we will be, and we're out for consultation on that now.
Yeah.
Have you got anything to add, Helen?
Do I look like I do?
You maybe. I'm trying to read.
I'm just, I was just thinking, so at the moment, we've always worked within our well-respected regulatory environment anyway, so there is a framework in place.
Yeah.
And any type of assets can be dealt with within that framework. This is just moving towards the international standard as it emerges.
I mean, to follow on from Deputy Wilson's question, is Jersey doing enough to embrace the new potentials for cryptocurrencies, digital finance, do you think? The message sounds very much like robust frameworks to protect, but are we genuinely open? Are we trying to recruit new business?
So I'm not sure, Helen, whether, or maybe you actually, Julie, are a little bit nearer to it from the other work that you've been doing.
Yeah.
We do have structures, we do have service providers here already, and they've still come, even though we've been clear about being robust. So we absolutely believe that Jersey is a place that is being used and can be used much more, but we know that there are risks, and so we've had to take a cautious approach in the way that we've done it. People have still using Jersey,
but is that in spite of the government, the regime, if you like?
Well, it's a good question, because do people come to a robust regulatory regime in spite of it, or do people want to have it as a kite mark that they are registered in a regime in a country, island, with a robust regime? It's probably a little bit of both. But Julie, do you want to say a bit more about what's already here? Maybe?
Yeah, I think we've got some very well regulated businesses on Ireland that reputationally carry weight. We have a robust AML CFT framework for those virtual asset service providers that they must comply with. And then any fund that has any tokenised asset within it or digital asset within it has to apply for COBO consent from the JFSC. They can't get the consent to operate the fund unless they have that. So we do have systems and controls in place. Like the Minister said, how far you go in regulating the rest of the conduct and prudential side. At the moment, there's so many different jurisdictions across the world that are kind of going different directions that you almost need to wait for it to settle before you kind of go commit one way or another, because we're at risk of stifling potentially quite a lot of business and innovation in this sphere unless we do. And particularly with the changing political climates both in the UK and the US, in recent months, it's having an impact and effect on how business flows in this particular sector. So I think everyone's just been waiting, pausing, seeing what happens, where the direction of travel goes politically before they're kind of making further commitments in terms of the regulation around this sector.
Okay.
Maybe if I just say one additional thing on it.
They might have a lot of other questions.
Areas
that they want to cover.
But it's
Tom.
interesting, and I know that we came to talk to you about these agreements into them. Just picking up on Julie's point, one of the advantages of working with the OECD is that, exactly as Julia said, it provides then a global common approach. So the way to think about the CARF is that this is almost an addition to a form of tax exchange of information. Clearly, digital assets, as I said, they do pose certain risks. We've talked about the regulatory ones, but another one is that you can have sort of transfer of those assets without necessarily interacting with traditional financial intermediaries, and that presents potential tax risks. So what we're saying as Jersey is that, right, as this new standard has emerged, we're at the forefront, we're part of it, we signed up to say that we will collect and then exchange information with other jurisdictions so that that tax risk is dealt with through this single approach. And I think in a complicated and fast-moving sector, if we can find global standards that allow for a common framework, so a set of rules, then I think that is a good thing for Jersey to get behind.
Okay.
And the Minister mentioned that there is likely to be legislative change
Yes.
around that.
Yeah.
And will that happen before the 1st of January
Yes.
2026?
Yes. So it's already out for consultation, and we've spoken to industry in advance of that. We'll then act on the feedback from that consultation. I mean, it's a consultation based on the agreed OECD rules, and then we will introduce legislation in the autumn to allow us to collect and exchange that information. So it will be added to our existing exchange of information framework.
Minister, can I ask, do you believe you've got a sufficient amount of time to get all of this work done and dusted and complete before January 2026? Because it seems relatively tight.
This work, the CARF work, yes, absolutely we have. The
And,
other
yeah,
prioritisation work, as is ever the case, things slip.
Yeah.
So we were targeting not just January 2026, but we'd be targeting that before we get to PERDA in 2026 to get all of that work done.
Yeah. Thank you. It's not specifically included in here, but the Pillar 2 that's went through, to what extent is that going to be a big work stream for you in 2025?
So most of the legwork around the implementation of Pillar 2 obviously will be done by Revenue Jersey.
Yeah.
Where we will pick up and support them is in any promotional work that we might do together, particularly stateside promotional work that we'll be doing with JFL, Revenue Jersey, and then from FS and ER side as well. But the actual legwork of making sure it's implemented and that they've got the customer service right will be Revenue Jersey.
Thank you. I'm going to hand over to Deputy Andrews now for the next section on consumer lending.
Yes, thank you very much, Chair. The panel notes in response to written question 308/2024 that you, in your capacity as external relations, will be lodging the consumer lending law, and we just want to know whether this is still going to happen on time.
Can you remind me the date I gave?
The fourth quarter.
The fourth quarter of this year.
Yeah.
So time's running out.
Probably, let's say, the consultation, the final bit of consultation is due to end on Friday the 13th, an auspicious day.
Yeah.
And dependent on what that consultation says, if there are no googlies or anything that we hadn't expected, then we perhaps will still be able to lodge by the end of the year. But if I'm being totally candid, I suspect it will drop until the beginning of next year.
Next year, okay. Because there were obviously a few concerns about some parties potentially not partaking in the consultation. And I just want to know, Minister, whether there are any concerns about you going out for consultation and potentially not receiving all the information that you'd like if you're then putting
Yeah,
forward
so I
legislation?
think this is Julie's field, and I think she's made a really good effort to try and engage with those that didn't engage previously. We will only know ultimately when we've got that consultation result back, and that you've really hit on one of the reasons that we might say to ourselves, we're still not satisfied that enough people have grappled with what is being proposed here to give us the benefit of their view.
And why do you think Jersey, as an island jurisdiction, requires a consumer lending regime in our legislation?
Because it's an area that we virtually everywhere else in the world regulates, and it's about basic consumer protection for those for islanders who are borrowing.
Yeah. And do you think there are already any protections within Jersey's domestic legislation already, if anything were to happen?
Well, there's a mismatch of quite ancient legislation. When was the pawnbroking legislation? Dates back to 1884. So there are bits, but you know, good luck to anybody who wants to use those ancient bits of legislation to think about their own protection in this field.
And can you think of any incidents in particular that raise concerns about breaches in terms of consumer lending practices, and why you really think then that there is a need for consumer legislation to be proposed before the States Assembly?
So it's something that anecdotally I think ministers and politicians have been spoken to about practice which is below the standard that we would expect. If my colleague, the Assistant Minister, were here, the Treasury Minister, she would say her experience while she was Viscount and dealing with all of those petty debts issues and those sorts of things, she would say it very much is needed, and she would be able to point us to evidence in her experience about why this legislation was needed as a basic protection for consumers. As I say, from my perspective, it's always been more of an anecdotal need to provide some protection.
So how much input has the Assistant Minister had with this particular work stream?
Well, of course, under the last government, she was leading on it.
Yeah, okay. And so when we're looking at the consumer lending regime, and if we're looking at, say, other jurisdictions as well, do you think the legislation potentially could be overbearing for businesses when we're looking at some ministers proclaiming that there is a need to reduce red tape, allow the economy to thrive?
I mean, you're asking me the million-dollar question about regulation. How do you regulate to give good outcomes for consumers and users of services, and at the same time make sure it's not burdensome and overly bureaucratic? We have worked, I think, really quite diligently to try and make sure it's not overly bureaucratic. We've done that by using existing legislation, so we're not going back and bringing in new ones. We've listened carefully to consultation from those parties who would be involved. We've got carve-outs in there so that we're not capturing things unintentionally. No. Our aim is to give a basic protection to islanders who need credit. Yeah. It's not to capture trust companies and financial services companies. It's not to capture things which are already regulated elsewhere. It's trying to provide that basic, because at heart we've had that question in our minds.
Can I just interject? So can I ask what some of the behavioural changes that you'd like to see? So what are the examples of bad practice that have been happening that this regime would seek to change?
Well, do you want to?
Yeah. So I think quite high interest rates, sort of bad practices of lenders in recovering debts. We're probably not talking about your main high street lenders in that regard. There's
like payday loans kind of stuff?
That kind of thing, yeah. The difficulty we also have in terms of collecting, I think there's a few tools in trading standards sort of toolbox that they can really take many steps in this area at the moment, and without support of a legislative framework, it's very difficult for them to actually
But in
demonstrate some of the
In
behaviours.
terms of very high interest rates, what can government reasonably do? Would it intervene to?
We can cap interest rates at a certain level, similar to how they've done in Guernsey and the UK. In Guernsey, they're capped at 100% of the loan value. So the intention is to align ourselves as closely to Guernsey's model as we can do, because most of the lenders that operate in Jersey also operate in Guernsey. So to make it as...
And is that 100% of the loan value over the period of the loan?
Yes.
So it wouldn't matter how long you took to pay it back? And are you comfortable with that, Minister, as a principle?
Well, that
Intervention?
you see in there, don't you, the challenge that we have? Because as soon as Julie said 100% of the loan value, you were thinking, well, that seems excessive. But it's not excessive compared to what people could currently do, which could be double or triple that.
Yeah.
And so we're trying to bring it down.
Yeah.
If we were totally, if it was us doing the lending, we would think that even 100% of loan value over a very short period of time was excessive and was exploitative.
Yes.
But we've got to try and find the balance, and that's what we're trying to do.
Yeah.
Yes, I also just wanted to ask Minister as well, when the legislation is to be brought forward, and of course there potentially could be more work to be done depending on the outcome of consultation, but what considerations will be given for boroughs who, for instance, are defaulting potentially on their loans, and of course that could have implications for the lenders. I just want to know whether there would be coverage for this within the legislation.
In respect of, sorry.
Minister, I'll try and simplify it as much as I can. So
You're talking about somebody that's making the loan and it's being defaulted upon.
yes.
Well, they already have processes, don't they? Within current, they can go to petty debts, they can go to court.
Yeah, but I just wanted to know whether this would potentially be incorporated within the law, or do you believe there is already sufficient?
Not in the primary legislative vehicle, no. Conduct and how they operate will be set out in the JFSC's codes of conduct and supported by secondary legislation. There will be unfair terms regulations which lenders will be required to comply with.
Yep.
Some of that will potentially relate to, and pre-contractual terms, some of that will relate to how they may, for example, have to go into a payment plan with a borrower that defaults rather than going straight for court action.
Yep.
But that is very much aligned with how other jurisdictions operate their own kind of lending and credit regimes. So it's nothing unusual to lenders that are operating in a regulated environment already.
No. So far, have you received any feedback regarding the Financial Services Commission's codes of practice in the consultation so far?
Yeah, we've had some closed sessions with the banks.
Okay.
They've concluded today. They've gone very well.
Okay.
Yeah, we've had a very collaborative process with the banks who've been very forthcoming in their input and have worked both well with the JFSC and ourselves to further those. And the intention is to then go through various different stakeholder groups. So we've dealt with the banks, there'll be non-bank lenders next, and then other groups we'll target as we go through to make sure we get the right feedback from parties.
So this potentially could be going into 2025, this work?
It's planned to.
Yeah.
Yeah.
Okay, yeah. Okay.
Okay, thank you. So in terms of the...
I was going to ask a question, which
sorry,
I'm
go
not
on.
supposed to. Were the panel thinking they might scrutinise it?
At the moment, we haven't come to that conclusion, but we will. There's
Well,
always a
just
potential.
We trust you.
If you let us know, you don't know, it's not about trust. It's about the public interest.
Yeah.
So I mean, we would obviously scrutinise on if there's anything that we go through the normal process of having briefings, and then if there's something that we need to scrutinise, Before Deputy Wilson takes over, there's a few more questions. Can I just ask about whether the Debt Collectors Code of Conduct, which was brought in a few years ago, is that something that you've built on? Is that something that will be superseded or become obsolete?
So it will become obsolete because it will be incorporated into a set of regulations that will then be supervised by trading standards and the Channel Islands Financial Services Ombudsman.
Okay, that's good, thank you.
So it should be strengthened.
Yeah.
And just to follow up on that one, this is an area that doesn't have any sort of international standard applicable to it, is it? It's all locally driven standard setting.
So the World Bank has issued what it thinks are good guidelines. Each jurisdiction interprets as they choose to, but there are kind of general standards and principles that most jurisdictions tend to comply with.
Right,
It's
okay.
not an official framework, no.
Thank you for that. So in terms of the Jersey Financial Services Commission's codes of practice, do you believe that they are robust and transparent enough to provide effective consumer protection?
They aren't yet complete yet. They are in the drafting process. I think it's hard to answer that question until they're in a complete state.
I think what we have learnt from this process, though, is that the more engagement we can do, the better. So having that programme of work to ensure that we're reaching out to those stakeholders, making sure they understand their obligations and the impact of any regulation on them is really, really key. So that's helped shape not just the primary legislation, but we're taking that forward into the next stage to make sure that we continue to engage and everyone understands. We've had really positive feedback actually from not just the industry but Jersey Finance as well in what we've done, and asked whether we can actually roll out that same process across other pieces of work.
Yeah, okay, thank you. So do you think there'll be a mechanism for some sort of regular review or public consultation around the codes and when you implement them?
For consumer credit
Yes.
codes, there will be public consultation. Yes, the JFSC do consult on their codes. This is just the preliminary kind of getting it into shape. Are we all comfortable? This is achieving what we want before we go to consultation. So it is very much that collaborative piece.
Mm-hmm. Okay. How soon do you think you're going to be able to conduct a review like that?
Of their codes?
Yeah.
It depends how quickly the JFSC move in preparing them. They hold the pen on them. They have conduct of them. We are moving quite quickly. We've just had 4 intense sessions to get through the first initial draft. We need to move on to further stakeholder groups. Obviously, Christmas is in between, so maybe sort of springtime they may be in a position where they can start to consult. But I wouldn't like to answer for them. It's their code. So
Okay. I suppose what we're just trying to drive at is what sort of milestones can we expect to see so that people can be confident that progress is continuing and it's not just being kicked into the long grass?
Well, that will be driven by the legislation. So if we get the legislation lodged December or January, let's say, providing the consultation is all fine, doesn't raise any issues, it will have its parliamentary process here. The Commission will continue to work with officials and stakeholders. So it needs to be aligned, basically, because we can't have the codes of practice from the Commission holding up the implementation of the legislation. We need to make sure it's aligned.
and we will have the second consultation or
Yes.
secondary legislation consultation that we have to go through as well. So when we come to do the regulations on unfair terms, the debt collection and any orders or other amends that we need to make, then we will obviously have a consultation process as part of that, which will probably be more able at that stage to give sort of more indicative timelines perhaps, because we'll be further down the legislative process.
Yeah, okay, thank you. Can you provide any clarity on which further exemptions to the pre-contractual regulations are required to bring the proposed regime in line with Guernsey?
We haven't yet consulted on any further exemptions. We've given indication of what we think they might be, but we need to share the draft order with industry to see if there are any other exemptions that may or may not be required. We have asked people as part of this consultation that's live now to reach out to us if those that we have indicated are not sufficient, so that we can start that process of collaborating with industry to find out whether there are any other potential exemptions we may need to build in.
Okay, thank you. And can you confirm if the government's rationale for discontinuing, what the government's rationale was for discontinuing the inclusion of commercial lending regulations?
Would you like me to take that one? Yeah. So there was very clear feedback during the consultation that we initially did that it would cause a lot of problems for small and medium enterprises. It would also capture a lot of international finance business that was not intended to be in scope. Feedback from small businesses that responded to the consultation themselves were actually they would not want that. They felt it would hinder their ability to get credit. So actually those that responded to us said they really did not want to be caught within scope. So we listened to that feedback and tried to
There's
ensure.
still a gap there, isn't there?
No, so there's not a gap for individuals getting credit. There is a small and medium-sized companies saying they don't want legislation to hinder their ability to get credit. because they get credit in a different way from how an individual will get credit, and obviously on different terms as well. So that sector of our community have said they do not want to be caught in here, and for all the reasons that we know, that you'll have a contraction of the market, the debt will become more expensive for those reasons.
So
There's not a gap for individuals.
is it going to be completely unregulated then, the commercial lending sector?
It's going to remain as it is.
Which is, what protections are there or safeguards for?
Well, you would expect that they would have recourse to law as they currently do.
So does that mean that you don't think there's bad practice currently taking place in consumer lending?
No, the commercial lending. So
Commercial, sorry, it's what I meant.
the indication in the consultation is that they were very clear, for the reasons that Julie's just articulated, that they would not want to be covered, that they are satisfied with how they are accessing credit now and how that market is functioning.
Okay.
I'll come back to that at some point later on.
Can I ask?
Can I add
just
a
like
little
to add
bit
to
more
that
as well? Is that we generally found that that's the business sector were actually getting legal advice behind a lot of their lending transactions anyway. So it's not that they were probably a bit more of a sophisticated borrower in that sense compared to an individual who may not have the benefit of legal or tax advice even around their lending. So there was a distinction definitely between individuals as consumers versus small and medium-sized businesses who are perhaps a different borrower in type who would have the benefit of that advice.
Okay. Thank you. Could you tell us what measures are being taken to ensure that the Jersey Financial Services Commission is sufficiently resourced and prepared to regulate consumer credit businesses once the legislation is enacted?
Well, they've given me an assurance that they will be resourced and will be able to do it once it's enacted. Whether they will, as we currently sit here, I think it's within their plan. They know that it's coming on stream and that they will be resourced accordingly to deal with it.
Mm-hmm. And in terms of that assurance, what does that look like? Is that in the form of plans to reorganise their processes, their workforce? What kind of assurance are they giving you?
That they will be able to regulate it.
What does that mean?
Well, just a minute. I cannot get involved in their operational decisions. The thing that we do with an independent body like that is that they have to give us assurance that they will be in a position to regulate. I think from conversations with them that will mean individuals and a financial cost that they will put in place to make sure that they can regulate it. So it will be people and money.
Will there be any way to recoup money? So through is there a penalty regime that's envisaged, and that's presumably not designed to create revenue, but it may indirectly? Is that something that's been?
It's not designed to create revenue, is it?
No, it sits within the Financial Services Jersey law to the amend. So the any civil penalties that kick in for a breach of financial services Jersey law will apply to this as well. There are penalties that may apply from the Ombudsman's perspective, but they're a separate stream too.
Where would those the financial penalties go to? Do they get paid into which pot?
Well, that's a good question because it's quite a live issue. So there is a provision within that law that those penalties are divided in effect between the regulator and used to offset the costs of that particular section of industry and shared with government. And we're just in the process of properly formalising how that split will take place. That will, of course, then have a knock-on effect of this as well. Helen, I'm not sure what the update is of where we are with that. I know it's an ongoing piece of work.
Yeah, it is ongoing at the moment. So any money from civil penalties can be used towards JFSC reserves, but at first they should be go towards offsetting the cost for that particular sector from which the fines come. There is a mechanism for a ministerial order to enable monies to be paid over to government, but also voluntarily, there is a provision in the legislation that if the JFSC thinks it should pay money over to government because it might be such a substantial civil penalty, it may do so as well. So we're just working through that at the moment, working out how we apportion those appropriately.
Okay.
Okay. And finally, for me, could you just explain, Minister, what initiatives will be introduced to ensure that consumers are aware of their rights and protections under the new regime?
Well, that will be an important piece of the implementation work once the legislation has been approved and that secondary legislation is approved as well. And there will be a publicity campaign. Obviously,
Are there any particular
the
initiatives that you think
consumer body will probably lead on that.
Yeah.
I would expect the normal sorts of campaigns from social media to radio to published material.
Julie did.
Will you be doing anything with providers?
We've been doing a lot of work with providers already as part of the whole collaboration piece. Yeah, and we will continue to do that.
And what kind of initiatives will you be doing with them to actually help them communicate that consumer protection rights will be enshrined in law?
Well, it will have to go into any advertisements that they place in any event. A lot of the not restrictions, but the regulations that we'll be bringing in, certainly kind of things like APR and sort of terms and conditions may apply. So they'll start to see things that will come through. So they're going to have to change all of their advertisements in any event, assuming that they're regulated here and they're not regulated in Guernsey or the UK, in which case they can stay as they are. But
So is it going to become, I was going to ask about disclaimers on advertising. We're used to hearing that about, your investment could go up or down. Is that likely, is that going to feature in the new?
to the extent that it's industry standard and it's not overburdensome, and we're not, by adding some in, obviously excluding others, we just need to be careful that we don't almost go too far and then look like we're excluding certain things from people's notice. It's drawing it to people's attention in the right way that then enables them to access the information that they need to access, and it doesn't become just a list of caveats in an advert, so that you can actually see the products that you're accessing at the same time. So we are working through that at the moment. Literally, the discussions I had this morning were entirely on that topic with the banks, and we are just trying to work through the actual sort of how it's going to come out.
The question is, given all of the work that's going on, we don't want it just to be there. It needs to become real for people, and I suppose this is why we're asking the questions as to what the public can expect to see, feel and think about it. So I think that what I'm taking away from that is that there's still some work to be done around how you target the communications and the engagement with people once the legislation is done.
Is it just worth mentioning the kind of transition period that we're expecting to demonstrate we have got some time before this comes into force?
Yes, the intention is that the law will become enacted or kind of go live on the 1st of January 2026, but businesses will have until the end of 27 to really become fully operationally compliant with the legislation, because it's as much, it's new to further down this coming year, I suppose 2025, then we'll be able to start looking at that engagement plan for consumers and businesses alike to make sure that they are fully up to speed. But we just need to get that little bit further down the actual development of the legislation before we can start communicating that message, because we don't want to go too soon, really, so that we haven't got anything to actually engage with people on.
Okay, thank you. Thank you.
I was going to ask, I understand that the Financial Conduct Authority in the UK has got quite wide-ranging powers in terms of intervening. So, for example, if there were adverts which they thought were misleading, they could ban them or force other compliance. Is such a thing envisaged in Jersey, and who would do that if so?
Similarly to how it exists already for terms of like investment business, we're not too far from the model how we operate already here in what we're proposing for consumer credit. So they will have the ability to make people withdraw a product from the market if they're finding that the advert from the market, if they're finding it is misleading, then they will have the powers that they have in relation to investment business similarly laid over to consumer credit.
Okay, that's fine. I think that's everything on this section, isn't it? Thank you for Have you got anything to add? No,
thank
so we look forward to that coming through. I think that's going to be maybe some public interest as well. I'm going to ask some questions about the consideration of bilateral treaties with UAE, but also the process for treaty approval following on from P6 2023. So we've had a short briefing on it, but I think we may have other questions. Minister, can you provide an update on the government's position regarding that proposition and how the Assembly will consider treaties and the bilateral treaty with the UAE?
So, of course, we dealt with the bilateral treaty with the UAE separately, and that's gone through our processes. The request from the secondary part of that legislation, that proposition, as we said at the time in our comments to it, was challenging, was potentially problematic, but that we were prepared to work with LAP and PPC, and I'll come back to PPC in a minute, on what might be possible. And of course, problematic really is an understatement for how difficult it has been. What we've done is categorise treaties into, in effect, three types of treaties. We've got the treaties where we are entrusted as the Government of Jersey by the UK government in right of the Crown to enter into international treaties. So you can see the entrustment there is an entrustment to the Government of Jersey, not to the States of Jersey. So we already have an issue there that the legitimate body is the government and not the States, and yet that's what P6 wanted them all to come to the States for approval. As you know, historically we have brought those to the States. So in doing this work, it's maybe not quite led in the way that we were expecting. So that's entrustments. We continue to speak to the UK about what's possible there, but the UK are clear that the entrusted document or letter is entrusted to the Government of Jersey and not to the States Assembly. Then we've got what we call applied treaties, so that's the free trade agreement elements. They obviously are negotiated by the sovereign state, in this case the UK, with other sovereign parties, and they of course engage with Jersey. They include Jersey to the extent that they are able to negotiate. We know that historically that's been really for goods, because that's replicated our relationship with the EU. We would like to see that extended to services. Our inclusion is included in the extent clause of there, so to the extent, the geographical extent clause in effect. And so you can see there that the treaty is negotiated by the sovereign state. It's not actually negotiated by us. They do it on our behalf. So we have to make decisions in that process, during the process, about whether we wish to be included in the territorial extent or we don't. So in the point of making that decision and asking us to be negotiated in, it's then very difficult technically for that then to come back to the States and for the States to say something different from having been negotiated in on our behalf by the UK government. With those treaties, of course, what we have negotiated is end clauses, so clauses by where we could trigger our exit. So we would be in a situation whereby the government would say to the UK government, yes, we'd like to be in that treaty, go away and negotiate this, this and this. If you can, they'll come back and say, well, we could do this and this, but we haven't been able to do this. Are you still in? We still want to be in. And we know that these treaties are affected very much by being in customs union with the UK, but that's another issue altogether. The only ability then for the states would be to make a decision to trigger the exit clause rather than to be included or not. So that's another difficult area that we continue to this is. I really should be letting Tom do all this because it's his bread and butter, and he's.
And that's under the FTA. That's
The
FTAs.
FTA. So you've got entrustments, you've got FTAs, and then you've got extended treaties. So things like World Trade Organization, UK's membership extended, where we're asked if it wants to be extended now. You potentially could make a case for saying that the states would be in a position to be able to say yes or no to that extension, although I think that would create a lot of work across departments in a way that they haven't really properly considered, so we're asking them to consider that. And also sometimes there are changes to these extended treaties which we are asked our view on without very much time to do it. So they're all largely those problems that we thought are problems that we've not yet been able to resolve. We have spoken to Legislation Advisory Panel on a number of occasions, and we're due to speak to them again, I think, next week. We've not yet spoken to PPC, but I've asked for a date to be put in the diary for us to go and attend upon PPC in that regard as well. Of course, the slight uncomfortableness is that we still had treaties that we needed to get over the line from a process perspective, not least of which is CPTPP, which comes into effect on the 15th of this month. So that really is a canter through where we are, sorry.
In terms of the bilateral treaties, are they different? Because would they automatically come to the States Assembly anyway?
Well, that's what I was trying to say, that historically we've brought them to the States Assembly. As we've gone and started to look at them in the round of all of the treaties, we've now got some advice which clearly says that because the entrustment is an entrustment to the government of Jersey, it's not an entrustment to the states of Jersey, it's constitutionally improper to ask the states' review on them. So rather than moving forward, you could argue we've gone backwards a bit.
This came up in the briefing, and it's something I was thinking about. Does the fact that somewhere like the UK Parliament, that the government can always rely on a majority anyway. So if things push came to shove, and even when they haven't got a majority, they've got a coalition. In Jersey, we have minority governments.
Apart from when we've got a coalition.
But even then, it's still a minority in terms of the numbers of the Assembly. So does that have an impact in terms of the confidence that any government can have in ensuring that it's got the support of its Assembly, which is the legislature?
Well, I don't think that's the issue. Of course, that is an issue with all that government in Jersey does, that it can't be sure of the view of the legislature on any given issue for the reasons you've said. I think it would be more sure, generally speaking, around an international treaty, because I don't think the states would largely want to overturn an international treaty that had been quite hard fought, although it might. If we take the trade and cooperation agreement, I think we can see that, generally speaking, States Assembly might not have liked everything that was in there, but recognise that it was in a sort of take it or leave it attitude, and the leave it was a lot worse scenario than the take it view. So you could argue that with some of the FTAs, that might be the view that the Assembly takes, but it's when it comes to entrusted, that's not the issue. The issue is the UK government is entrusting a prerogative issue to the government of Jersey and not the states of Jersey, so not the legislature.
Has that become a problem since...
It's the UK government.
Has that become a problem since ministerial government? So
well, we didn't do entrusted treaties prior to ministerial government, did we?
No, I think I don't think it's a machinery of government issue. It really, as the Minister has said, we were posed what sounded like quite a simple question in P6, at least relatively simple. And in fact, looking at it diligently as we've done, and then getting the legal advice on it, it turns out that it is actually quite complicated to try and satisfy the different requirements, practical ones, as the Minister has said, but also legal ones around how we take agreements forward. Because it's a prerogative power, I mean, let's step back a minute. Jersey doesn't have in itself treaty-making powers as a sub-sovereign, but there are absolutely reasons why we want to engage with sovereign jurisdictions at the international level through binding treaties. Of course we do, and we have done for a long time. The process for that is that the UK entrusts to Jersey that treaty-making power. But when it's making that entrustment, it is to the executive, because it's executives that make treaties.
So can I ask, what does Guernsey do in this regard?
I think what they do is they do like a letter, a policy letter. In some ways, it's not. I mean, I'm not an expert on Guernsey's system, but in some ways, what we're thinking about doing and what we've discussed with you as a panel is the idea of moving to a model that would be similar to that, and in some ways similar to what we've done with free trade agreements, where we would be presenting a report. I mean, I think what I hope we could all agree on is that we think we need more regular briefings to states members in advance of, on plans to negotiate. Of course, negotiations go in different directions, and we're not always negotiating. Sometimes it's the UK, but we could certainly do something that's about the treaty pipeline, and I think we're doing that. I hope you feel that we've been providing with more information. Then I think there is this idea of a set period when the Assembly could scrutinise the different types of treaties, and one method there could be around the lodging of a formal report, that would contain, information on what the plan was or what we intended to do. It won't always be the case in every case that the full text of the treaty may be available, maybe at an earlier stage in the process, as the Minister has outlined, where we're sort of giving an in-principle position. And then I think the key point is that there is this mechanism to suspend, the treaty, participation in the treaty, separate to the UK if it's a UK free trade agreement, or of course bilateral if it's our own, if that is the will of the Assembly. I think those are, to my mind, the components that are in there. But the one thing I would say is, maybe this is just a personal point, we do need a process that's going to be reasonably quick for us to be able to complete it. We need a workable process, because I think it is a good thing for Jersey to be able to enter into agreements of all different types and sizes with a range of partners, whether those are under entrustment or extended. We need something workable, because every time we do that, I think we advance the island's reputation internationally. So that's the thing we need to sort.
Ultimately, is there a way to satisfy the spirit of what the Assembly asked for, and in particular the movers of those propositions, in terms of what you're offering? And have you gone back to those, and then are they satisfied with what's being proposed?
Well, it's a good question. The reality is, of course, one may be and one may not be. So it doesn't really move us forward very much, because there might be disagreement at that level as well. I just want to go back to your Guernsey question. I think it's something we will definitely take away. But I would just say, we were doing something that Guernsey might currently be doing. So they could be entrusted, PNR could be entrusted in Guernsey to do it, then they're taking it to their Assembly for ratification. That's what we were doing. But what the advice has now shown, when you've drilled down into it and looked at it, the advice is, and the UK government's looked at the advice, has come back, no, actually the entrustment is the entrustment with, in our case, the government, the relevant minister. And so we do need to talk to Guernsey, because there might be onward implications for them, which we hadn't thought about in that regard as well.
Thank you, Chair. So just so that I've got this fully understood, so really the entrustment is the issue, isn't it? Because it's government.
Sorry, there's issues with all three types of treaties, but yes.
Okay, so but in principle, I think what I've heard you say, Tom, is that the business of governments is about developing treaties around the things that they mutually agree need to be in place, and that the role of parliaments or assemblies or whatever is almost to hold
parliamentary process. And that, I suppose, is the question we were being asked. What is the parliamentary process in Jersey for international treaties? And you first come back to that first question, we can't in our own right as a sub-sovereign sign or enter into international treaties. But what you can do then is divide it up into these three different buckets. And one is that entrustment process where we are entrusted to sign into international treaties as the government of Jersey.
Does this include so double taxation agreements? They're part of it and
They are,
entrustment?
yes.
So could I ask, is in terms of maybe the spirit of what the Assembly was maybe asking for? I think the Assembly, understandably, wants to have some kind of potential input into the thought processes before a treaty is signed, any kind of treaty. Is there a way to actually try and front load some of those discussions, especially where it's considered to be more relevant? So, for example, if Jersey were entering into a double taxation agreement with Portugal, you'd have thought that there may well be something which more members and even civic members outside the Assembly might wish to have some input in. Are there ways to build that kind of consultation in before you get to the point of having signed a treaty?
Well, that's interesting because you do some consultation in the process of before you actually sign up, or even during your negotiation, don't you?
We do.
You will come back and then...
And is there any possibility for formal legislative scrutiny maybe to happen before? So could the LA, or whichever body it might be, look at treaties confidentially to have input?
Yeah, I think the confidentiality part of that would be important, because if it was a treaty that was under live negotiation, your negotiating team from either government, certainly from the other government, wouldn't expect that their treaty drafts were sort of out and about being discussed in real time. But I think certainly what we have thought about is that, we obviously, I should say just for the record, because you're familiar as a panel with it, but maybe other people aren't. You, of course, as a scrutiny panel, are briefed on any international instrument before it's signed by a minister. And we do that, as a courtesy. And of course we have, and because it's the right thing to do. And of course we also provide ongoing confidential updates to your panel on our progress that we're making on an ongoing basis in respect of agreements. I think over and above that, what we could consider doing is, if there is interest, would be to do all states members briefings, on a regular basis, and that's something we have discussed as an idea, and would be up for doing if we think that would be.
But is that before they're signed or after?
Yeah, and I think we would use that to talk about the treaty pipeline. Yeah. So to talk in, these are what our treaty aspirations are. These are the sort of partners we're considering. It would seem to me that approach could then allow for members to express particular interest in a work stream. I think we need to then think about how do we satisfy that interest in a way that also fits with our ability to get on with the negotiation and make a success of it. But I think there is scope there. Just to the point on consultation, we do talk to industry, of course. So for example, double taxation agreements, we make sure that we engage through JFL with their tax community, so that we talk through the implications, make sure those are understood, and that's ahead of concluding drafts, because it's important that we do that. But I think what you're talking about is a more general public engagement, and I think certainly starting with briefings with states members, if they have interest in it, would be a good way that we could do that. I also think that the reporting function should help with that, if that is where we land with this. And in some ways it would be mirroring, if you like, what's done in the UK, where there's a laying before Parliament of a treaty.
Could you sign a treaty but forward date it so that it doesn't come into effect until, say, 2 weeks, 3 weeks in the future, and then and even if you didn't necessarily bring it for debate, there's still that 15-day period where a member can call in anything. I don't know if it's anything, but certainly can challenge a ministerial decision, and that's the risk, isn't it? Because any member could say, we don't like you entering into a treaty with that country because we think it's got a terrible human rights record or whatever, and then there would be a debate, but you wouldn't be in control of that process.
So it's a good question, Chair, and it is a question that we thought long and hard about. At one point, as we were going through all of this, that was a proposal that we produced. But subsequent to that proposal, we then got back to this advice, which was very clear about entrustments, which basically drove a coach and horses through it and said you couldn't even use that methodology, because we were thinking of You'd lay it before the States for 15 days or 20 days, however long, much like you do with property transactions, and any member could call it in. If it wasn't called in, it would in fact be in a negative approval process that not called in, it then comes into force. But that advice was very clear to us. So it was, it was clear, unhelpful, of course, in trying to find a compromise, but very clear that didn't work and we couldn't use that methodology.
The problem that's a specific legal problem with entrusted agreements. So just to be to reiterate, that there are practical problems with the other types of treaty, which are to do with the fact that they're not fundamentally.
Can I just go back?
Yeah.
How do we scrutinise that advice?
Well, that's a good question, because that advice is always confidential.
But it's an
But you
opinion,
could-
right? It's a legal opinion.
I'm just telling you the advice.
Yeah.
You know the rules around
Yeah.
how we reference advice.
Yeah.
I'm trying to stick to those rules. You could, of course, ask advice on behalf of the panel on these questions.
Yeah, thank you. And sorry to cut in, man. I thought.
It's
not
a
at
good
all.
question.
Yeah, absolutely. I think the practical point, it runs a bit like this, is that under an entrustment, because the prerogative power, the treaty-making power, has been given to the executive, if you introduce any kind of conditionality to it, that essentially means that you're saying the executive's power is curtailed subject to, an outcome in Parliament, you are therefore implying that that power is not held wholly by the executive, but is in some way partial or shared. And that is the advice that we have had, is that the entrustment is wholly giving that prerogative power to the executive and to the executive solely. So you're asking, in effect, the Assembly a question that it does not have the vires to answer in that circumstance. And that's why it has proved problematic for us to find a way to address, if you like, the some of the ideas that were in P6. But as I say,
Sorry, Tom, just on that, but could the executive choose to ignore the view that comes back from the Assembly?
well, I think the problem with P6 was it was looking for a legislative provision to sort of allocate that power of ratification to the Assembly. And that's the thing that legally speaking, that's what we were asked under P6 to do. I think, as I've said before, the current situation where we're at is that any member, as you know, can request to have a debate on an existing treaty and could request for Jersey to be, to withdraw from that treaty. So, that exists currently. I mean, I can't speak for the minister on this, but I think clearly if that was a decision of the will of the Assembly, I think it'd be extremely difficult for that to be, disregarded. But there's no change to that current position. The difficulty is, can we introduce legislation that formalises a ratification procedure? And for the reasons that we've given, both practical and legal, it is very complicated to try and achieve that.
No, I get that. So is the bottom line? Can you tell us whether are you going to pursue a way to try and square the circle, or are you just going to? Will you likely come back and just say this is not possible?
Well, we've got our proposal about laying them before the Assembly's reports, trying to do more briefings, speaking to you guys, doing a policy pipeline, picking up some of the points you've just made about asking for individual member interests, thinking about how we can consult perhaps with you or interested members during that negotiation period. We can't see another easy way through this as we sit here, but we are still circling back round to LAP. I think LAP are going to want us to pick it up with the UK government again. We'll do that, and back to PPC. So I think you've questioned us. I think we've briefed you previously as well. We're still in a difficult position, but that we've currently got some proposal.
Yeah.
But back to your other question, that will only satisfy probably one of the movers of P6 and not the other.
I'll wrap this section up, but does it ultimately come down to the fact that there's perhaps a misunderstanding generally in some quarters that Jersey is sub-sovereign. So actually we've got delegated, certain things we can do, but is that part of the issue, or is it more to do with?
I don't think it's a misunderstanding that we're sub-sovereign, but we are sub-sovereign, and yet at the same time, we are always seeking, where possible, when appropriate, to enhance our autonomy.
No, thank you. That's useful. I'm going to move on, if that's all right, to the next section. I'm only going to ask a very brief question about the Financial Intelligence Unit, not because it's not important, but I think we're going to follow up with some written correspondence. But if I can just ask for the record, is it still your intention for the Financial Investigation Unit to be a standalone piece of legislation, and rather than included with the proceeds of legislation?
Yes, it is.
Crime.
Yeah,
Proceeds
it
of
is.
crime. Yeah, it is. And when can we expect that work stream to begin and possibly end?
That's a good question. They're moving into new offices. I think we're hoping that the entire process will be completed by the end of next year.
Okay.
Yeah, that's one of the prioritised pieces of legislation. So there's sort of three parts: the kind of physical removal from the States of Jersey Police Station into their own property, the separation of the IT systems, and then the piece of legislation that creates this statutory body as the FIU.
Thank you. As I said, we'll follow up with some written questions in that. Thanks for that. I'm going to hand over to Deputy Wilson now.
Okay, thank you, Chair. We're just going to pick up on the strategic review of Jersey's regulatory environment and the data breach findings. So on the 24th of July, Minister confirmed that a strategic review of the regulatory environment would take place during 24 and 25 as part of its post-money ministerial priorities and high-level action plan. 3rd of October, the JEP published findings into an investigation into the JFC. And in your article on the 13th of October, you said that government would be exploring a third-party appeals process, and that followed a further article in the JEP on the 23rd of October, where you were suggesting a special committee be set up to oversee the independent regulators. And an FOI request was made but denied under Article 36 on the 24th of October, which was requesting the strategic review's terms of reference, within which the publication was confirmed to be within the next 12 weeks.
Do you want me to take the FOI?
You take the FOI, because of course ministers don't involve themselves with
Sure.
FOIs, they're just answered independently of political input.
Yeah, that's okay. So I'll just finish that.
Yeah.
Sorry.
It's all right. And then going back to the beginning of the year, there was the JFSC data breach, and the investigation into the breach was conducted by the JOIC, and a further breach occurred in June 2024. So the question in all of that, I'm very sorry to get round to it, but to set some context, again for members of the public, is are you able now to update the panel on the status of the strategic review, and can you tell us, can you confirm when the terms of reference will be published and outline what these will include?
Do you want me to do the data breach first? 'Cause I
Please,
think that's
yeah.
quite
Yeah.
important. So I met with the JFSC yesterday. They confirmed to me that they now have the root cause analysis of the data breach from the independent parties that done that review, and there's a board of commissioners have also produced a management response to that review. I am expecting that review and the management response to be on my desk today. I haven't yet seen it in my inbox, but that's what they said yesterday, so it will be happening during the course of today. I was very clear with them that, of course, I will want to look at it, but you as a scrutiny panel will also want to understand what happened and not just take my word for it, which is, of course, why we've asked the JFSC to initially to do a private briefing on that report. So after that report, you'll know more than I have. By the end of the day, you will know more than I do, because I've not had time yet to read the report. we will clearly read through that report and consider if there are any other actions that we think government needs to take. It might be that we initially actually need a technical expert, because it's quite technical, all of the technology stuff. We might even need a technical expert to give us a once-over on the management report in response to the independent review. So that's where we are with that.
Okay.
So we're nearing to the next stage of completion, but that may lead to other pieces of work. We had a finalised draft of the terms of reference for the regulatory review work. We have been considering who might be appropriate to do that review work, and that has led us in that consideration to, in a way, divvy up some of the work. So we'll be using, and Helen, maybe you could talk a bit more about that, some of the more mundane review work, looking at the laws and policies and all of that. We think that can be done by a working party domestically, because they're best placed to look at it. Some of the more strategic and jurisdictional comparison work, we've got two current, which I can't name now, but you will name in due course if they say yes. We've got two individuals that we think can work together with great experience in this area. It won't be a vast expense, and then they will help us deliver that other bit of the review, and that's why it's not quite been published in the way that we had initially envisaged when it was announced. But we are, I would say, before Christmas we'll be in a position to be able to publish the terms of reference, unless Helen's going to tell me this.
So the reason they weren't published at the time when the FOI request came in is because they were going to be published in the ordinary course anyway, and the Minister had said that in the States Assembly, so they will become public. The strategic review we split into two parts, as the Minister said. So the first part, I've tasked Jersey Finance with pulling together a working group across industry so we get a balanced view of the regulation. We know sometimes different sectors, different lawyers don't even agree on the same question, so to really make sure that we've got a fair and reasonable assessment of that legislation. So that's ongoing, and Jersey Finance are pulling that together. And the second part is the strategic piece. But yeah, we hope, I think I sent to you just earlier today some track changes, so I hope that we'll be able to share those very soon.
Okay, thank you. Can you confirm whether it's your intention to still include the JFSC in the list of organisations that are subject to FOI legislation?
So the two things in your framing of the question, which were not quite, might have been reported in the paper, they're not quite what I said. What I said was that I have no objection to us considering the extension of FOI to the JFSC. What I am absolutely clear on is that quite a lot of data that the JFSC has got can't be individual data, but anonymised data can be published and put into the public domain to help with transparency, whether that's number of applications that they've got, turnaround for applications, lots of sort of basic data that would go a long way to helping deal with transparency. I also think that if, as I said, if we can deal with the exemption, which is currently a qualified or partial exemption for commercial information, if we can deal with that in the overarching law, then any residual objection would fall away to FOI that I might have. We'd have to think about the cost, but I think if you're already putting anonymised data around performance into the public domain, there's not that much else that FOI would actually require, because you wouldn't have FOI talking about individual enforcement cases, because that would be in breach of data protection, and you couldn't do that on an ongoing case. So there are ways of dealing with it which would mean that the burden for FOI, I think probably when it comes, will be much less than might be initially envisaged at this point in time.
Okay,
You then asked about the committee. I think I answered a question to you, Chair, in the States, where I said we are trying to look at different ways of dealing with the accountability issue, which all regulators have, not just the Commission. So let's not just point the finger at them. All independent regulators have. And I was open, and I simply said that if you go to the US, they have committees that oversee these things. I think that you as a scrutiny function, and this is not me passing the buck, but I think let's see how this briefing goes this afternoon, which I know is in private, but it doesn't seem unreasonable to me, and we discussed this yesterday with the Commission, that the Commission DG and the Chair doesn't appear before scrutiny on either an annual or a 6-monthly basis. There are things like this which will enhance accountability and transparency, which could be quite easy to deliver.
Okay, so that sort of fed into my next question around how you would manage some of the regulatory environment, and I know what you've just said there, but one of the things I wanted to do is ask you a question about the data breaches in particular, which occurred earlier in the year. Are you able to provide us with an update of investigations into how the January breach now occurred?
No, because that is the report that I've just referred to,
Okay.
with the root cause analysis report, which I'm expecting, as I said, in my inbox. It might be physical, of course, being delivered to the office during the course of this working day.
Okay. And the other questions I have about other breaches, I expect, will be incorporated into that report.
They're all encompassed in that one piece of work, as I understand it, yes.
Okay, and just very finally for me, can you explain your approach to managing a competitive financial services environment with the need for regulatory change, and what improvements are you committed to making there?
That's so. I'm just going to say that is a question, which is a very good question, which I can't answer in 2 minutes. It's important that we have the base of a strong regulatory environment, that we've met the standards of Moneyval. That's the basis that we can operate from. But it's equally just as important that we're thinking about how competitive we are in every area of financial services. So that's how quickly does the regulator say yes or no in its authorisation division? How quickly does an enforcement action take? How responsive is Revenue Jersey to questions from businesses about tax questions that it might have? And that's at the heart of what we're doing with the customer service element of the Pillar 2 implementation. How dynamic are we in regard to tax matters, thinking about the global changes that are taking place? How quickly do we in government are we able to deliver on new products and changes to legislation, and how can we consult in a more effective and timely way? And Helen's already doing a lot of work in that arena. And then, importantly, how do we coordinate across government from a promotional aspect, so business to business, government to government in the same jurisdiction, or what we're finding on the government side more and more, industry can do lots of its work, but actually lots of businesses, not to the same extent that industry does this. They're wanting to see government, they're wanting to see regulator, and they're wanting to see industry all at the same time. So what people have when they come to Jersey, i.e. they can go up and down the Esplanade and across to Union Street and see all of the decision makers, they're wanting that, but almost in an export package, so that we can go out and do what we have here, but present it to them in their home jurisdiction and in their home office. So it's a good question that we need to never stop answering.
Okay, maybe we'll come back to it again.
Yeah.
Thank you.
Thank you. Minister, we come to the end of the hearing. If it's okay, there's a couple of areas which we'll follow up on in writing, so to do with Moneyval and intellectual property, as well as the financial intelligence unit.
So my assistant minister responsible for intellectual property